Is a last will and testament sufficient? Well, a last will and testament, or simply a will, is the first and foremost of your basic estate planning documents. Now, every adult, whether you have a small estate, an estate of great wealth, or something moderate, or something in between, you probably need a will. You should have a will. If you're a young adult, 18, 19, 20 years old, even if you don't have a spouse or children, if you have any sort of bank account, you probably need a will to prevent against problems. Listen, if you passed away, that's a big enough problem, but problems for your family members that have survived. So even if you have great wealth, a will is probably part of your entire estate planning needs. Perhaps a will, a trust, advance directives, maybe some other instructions. But a will is where you start. Most people have heard of a will. Many people do not have a will, right? A will, unlike other legal documents, will be completely valid and legal when executed properly, but it does not take effect until your death. That's compared to contracts or even a trust. They take place during your life. The will can be legally valid, but the way it's designed, it doesn't take effect until after your death. A will could be contested. Most generally, they are not contested unless it can be demonstrated that there was something done incorrectly or something was amiss when the will was executed. Fraud, duress, gun to the head. Right? Other than that, mostly they are not, well, especially if they're written and drafted and fully observed the execution by an attorney. A pro se will, a will done by a person, has a greater chance to be contested. If you get a will done by an attorney, there is a presumption within the law that the will is valid. It does not mean a will cannot be contested. Wills are contested. So in the population of surrogate court litigation, will contests are a large part. It's just that in the totality of all wills, most are not. You don't want that to be your will that's contested. So when a will is created, it'll provide instructions about what you want to happen, where you want your money to go, and who you want it to go with. You're going to, if you have minor children, put in for care of your children. You're going to have distribution of your assets. You're going to name an executor. And you might even have some other requests. I'd like to be buried in this cemetery, or I'd like to be cremated. Although a person would need to know where your will is to actually effectuate that desire. You might want to put that into another document. I want to keep this brief. You know, I'm a lawyer. Sometimes we're not that brief. But I like to be simple and straightforward and tell you what my understanding of the law is. Okay? If you'd like to speak with me about your will, please go to frankbrunolaw.com.